Were you able to obtain instructions from the Attorney General, Attorney General then being Mr. Albert Kawana, whether he got back to the Minister of Fisheries?
I did not get that.
I want us to go back. I know that we've now dealt with the agreement, but you testified how this scheme was set up, and you referred us to various documentation during examination in chief. Do you recall?
Yes, I recall.
Do you have Exhibit XX6 there with you?
Well, my documents are not marked, so
It's the one marked volume 7.
just give me the page, maybe. Start with page.
It's
It's
written
786.
volume 7 on top, big.
It's 786.
786, yes.
Yeah, I do have.
Now, what you testified was that there was a meeting that was held in Angola during September 2013 where the Nemgomar scheme was discussed. Do you recall that?
Yes, I recall.
And you've indicated that members of the syndicate attended to that meeting.
That's correct.
Now, I'm not sure if you are aware, but Mr. Esau came to testify that he gave no one permission to attend to any meeting on his behalf, and he was not aware of such meetings. In particular, that meeting.
Yeah, he was not part of the meeting, but I cannot agree that he was not aware of the meeting.
Apologies? Please repeat that.
I said, I cannot say that he was, I can confirm that he was not part of the meeting.
Yes. He's also saying that he was
But
not
I
aware of the
disagree
meeting.
with him to say that he was not aware of the meeting.
Of your investigation, did you find any evidence or any documentary evidence depicting that he was aware?
Yeah, there were some letters that was forwarded to him,
Which letters?
which regarding to what was being discussed, or which regarding to the establishment of the special vehicle that have to be used for that scheme.
Which letters? Be specific, Mr. Kayangela.
There were letters from Ricardo Gustavo that he wrote to him, and the other minister of fisheries in Angola.
When?
I cannot give the specific date, but you can come to the letters if they are part of the bundle.
No, you must tell us, unfortunately. I won't know. Because he's saying he was not aware of these meetings. We are now still on the meetings.
Did you already testify about the letters? Those letters that you are talking about from Gustavo. Did you
Yes, my
testify
lord, I do
about
have
them?
testify about them.
You did not.
I did.
Okay.
Your Lordship, I'm not aware of letters that was written by Ricardo Gustavo directly to the minister. That's referring to the discussion of the scheme.
My Lord,
Unless
I
the minister can
specifically led the witness on the letter, my Lord. Let me just check which part of the bundle is it. It's on page 817 of X.
That's the next document.
Okay. And that is the particular letter dated 18 December 2013.
That's correct.
And Mr. Esau came to testify that this particular document, it was directed to him, but he just forwarded it to the office of the permanent secretary. He did not peruse and consider this particular letter. And during that time, it was also during the time of the death of his brother.
That is his testimony, but I disagree with his testimony. I don't know why he was in the office. If he was having a problem with his brother's death, he could just put in leave. Why should he be in the office?
Are you asking me questions?
I'm not asking you questions.
Okay. You are
I just-
entitled
I
to
ju-
respond, not to
I
ask me
just saying
questions.
he was supposed to put in leave
You are supposed to.
Yes.
Yeah, but people act differently. You can't decide what people should do.
Okay. But I'm not agreeing with that he did not see the letter or did not read the letter.
Let's go back to 790.
790.
You also testified that this particular email was an email that was extracted from Mr. Shangala's device. Correct?
From Mr. Shangala's device. I never said so.
Where was this document obtained from?
I said these were documents that came from the office of the district prosecutor in Iceland. I never say it is from Shangala's cell phone.
Now, if an email indicates Zacchaeus Edward Shangala, are you there on top?
Yes.
Do you know how printing of documents work?
How?
Printing of an email works.
The
If you
printing-
open an email and you print the document,
Yeah, you can print it.
whose name would appear if you print from that person's email? Whose name would appear on top?
It can be the name of the person who is printing or to whom the email was forwarded.
That person's name would then appear on top.
Yes.
But in this case, Mr. Shangala's details appear on top.
Yes, it's his name that is on top.
Now, what I'm putting it to you that this is not even an authentic document.
I don't know. Unless you provide me with one which is authentic.
You are the one that is supposed to provide us with authentic
To me,
documents.
it's an authentic document.
But we will take this aspect further. For now, the purposes, the court has decided that the relevant documents are allowed. Now, if you turn the page, Mr. Kayangela,
Maybe before you proceed, about the name that appears on top, it sounds as if you are being of assistance. In other words, if one prints an email, whose name will appear on top?
Yes.
I don't know what you are saying about that.
the proposition that I'm making, Your Lordship,
Yes.
is if one goes and they open the email today,
Okay.
and you print from your email, Microsoft Outlook or from Gmail,
Yeah.
your name will appear on top as if the email was printed from your email.
Okay.
So, for example, if I send a letter to Mr. Kayangela and he opens it, an email,
Yeah.
and he prints it from his device, from his email,
Yes.
it will show his name on top.
Okay.
If I send the email, and if I print it from my email address, my name, Florian Beckers, will appear on top. So
Okay.
therefore, the proposition that I wanted to explore was that if it's printed in Iceland and it's obtained from Iceland, then it would mean that the person who printed it there, or if it was from any of the parties who received it, their name would appear on top.
Can Mr. Kanyangela comment? May you comment to that?
My Lord, the only person who can explain as to how this document was printed is the people who provided it. And if it was extracted from any of the devices, the auditors who were given the task will be able to explain. I was not part of the process of analyzing.
So you then do not know whether this email was extracted from the device which Mr. Shangala refused to give his password, or whether it came from the prosecutors in Iceland.
What I know that it came from the prosecutors in Iceland, but I don't know how they got it.
So, Mr. Kayangela, you specifically cannot verify the authenticity of these documents. You are in any event a secondary witness.
The person who extracted it will testify on its authenticity.
Can you verify it? Yes or no?
No.
Let's go to page 791.
Yes, I'm there.
Now, you've indicated that these were summary and action points of a meeting that was held, and these notes were in essence prepared by Is it Mr. Shangala or Mr. Sigi?
I never testify about that.
Page, what page, ma'am?
Page 791. You testified on this document.
I never testified that it was prepared by who.
Okay, who prepared it?
I don't know.
You don't know.
This is a document that was presented to us by Mr. Johannes Stephenson, and he was part of that meeting.
But you don't know who prepared it. So anyone could have prepared it.
There's no name of the person who prepared it.
Meaning that Mr. Johannes Stephenson, who's a self-confessed criminal, he could have typed up this document and given it to you.
I never hear him saying that he's a first confessed criminal.
I'm putting it to you, Mr. Kayangela, that Mr. Johannes Stephenson could have typed up this document. He could have. You won't know.
Yeah, he would.
And this document is not signed off by any parties or any persons.
Yes.
It also does not constitute minutes of a meeting.
Yes, it doesn't have minutes.
Minutes are normally signed between the parties that attended the meeting to confirm that the contents there is a true reflection of what transpired at the particular meeting. Correct?
But the document itself, it talk about action points that have to be taken, which means its content, it contains of what was being discussed. That's why the parties have to take action. They come up with these points.
Did you listen to my question, Mr. Kayangela?
You can repeat your question.
Do you recall what it is?
I say you can repeat.
I please want you to listen to my questions and just answer the questions that I'm asking you. The question was, minutes are normally signed between the parties that attended to a meeting to confirm the correctness of those minutes,
Not all the parties.
or by the chairperson.
Yes.
And in this regard, for meetings that were held, anyone could have drafted this thing because they are not signed off.
But these are not minutes.
My Lord, I don't know, it's not an objection, but we are being troubled by things which don't follow from the documents, my Lord. This document is attached to an email, and the email specifically says, please find attached here to an action document. It doesn't say minutes. And I don't know why my friend is trying to say these are minutes.
All right, that's fine. Mr. Baker,
Your Lordship, I will rephrase. This document, like my learned friend is now testifying that it's attached to the email, one can't confirm that this was actually attached to that particular email. It's only the author of this document that come and confirm. Is it not so?
I still say that this document was attached to an email. I come across this document in many emails that were just provided when it was being shared. It appeared a lot in many of the emails. I think if the emails were disclosed to you, you have to go through those emails and see that it was an attachment to an email.
But you do know that we are challenging the authenticity of those emails.
Yes, you can challenge it. That's why I say
Let's
it's
move on.
authenticity. Okay, we can move on.
At paragraph number 11 of that particular document, it refers to the draft agreement will be sent to the Ministry of Fisheries and Marine Resources tomorrow. You took us through that particular part when you testified, paragraph 11.
Yes, number 11, yes.
And in your investigation, could you establish to whom in the ministry this agreement was allegedly sent and when it was sent?
I can recall that the draft agreement or the draft protocol that was submitted, it was submitted to the applicant by the office of the permanent secretary to go through that, and the applicant, he give advice that there should be brackets to be removed from that draft. And that was during I think it was on the 19th of September 2013, if I'm not wrong.
And who submitted this agreement with the permanent secretary? What could you establish in your investigation?
I don't know who submitted it to the office of the permanent secretary.
So you can't be of any assistance.
No.
It also, at paragraph 12, indicates that the minister is to be briefed today. In your investigation, could you establish who was supposed to brief the minister and whether the minister was briefed?
There was no specific person who there's no indication as to a specific person who have to brief the minister, but he can only be briefed by those who attended the meeting.
Could you find any evidence to that effect, besides drawing conclusions from this document?
Who else could? It's only those who attend the meeting who can brief the minister of what was being discussed.
Mr. Kayingela, listen to the question. And I would implore your Lordship, or request the Honorable Court to please ask the witness to answer the questions. My question is, could you find evidence to support this proposition or this averment here that the minister was briefed and that there was a briefing?
I could not get that evidence.
So what you are doing, Mr. Kayingela, and I'm putting this to you, is that you've gone through some of this documentation, and instead of investigating the accuracy contained therein and what basically transpired and whether these things happened, you just drew conclusions from these documents.
The documents were supported by a statement of Mr. Stephenson.
So we are just supposed to accept what Mr. Stephenson is saying, the self-confessed criminal.
I don't know whether it's a self-confessed criminal.
But you want us to accept his statements.
You can accept it if you want. If you don't want, don't accept it.
We are not accepting it, and we are challenging everything that he's saying.
The challenge, you have to put it on him.
Now let us go to page 794.
Yes, I'm there.
You testified on this particular document. Can you please just identify it for us again? What is this document?
This is Samaria, Angola, Namibia project.
Who prepared this document?
I don't know who prepared it.
You don't know.
No.
How did you come to learn of this document?
The document was attached to the statement of Johannes Stephenson as well.
So Mr. Johannes Stephenson could have prepared this document and put in anything in this document that he wanted.
He was representing Samiri and he could prepare it.
this summary or this document is not signed off by anyone.
That's correct.
It's just a typed out document, correct?
That's correct.
This particular document, you will not be able to tell this honorable court whether this document was even shared with the first applicant, Mr. Esau, or whether he was even briefed on this.
I cannot.
Now, you also testified that there were meetings held in Iceland, do you recall?
Yes, I recall.
And during one of those meetings in Iceland, let me rather rephrase, when was this agreement reached, so-called agreement reached, that 75% of the usage fee would be paid to Dubai and 25% in Namibia?
It was also agreed in Iceland between James Atikulipi and Mr. I think it's Ingvar Jurison, or one of the managers of Samari.
And you won't be able to tell this court whether any of the other parties were even aware of this arrangement.
The other parties could also be aware.
You say they could be.
There was a message that was retracted from the office of from the cell phone of Mr. James Atikulipi, and it was also talking of the same thing, of the 75% to be paid outside Namibia and the 25% to be paid in Namibia.
To who was this message?
I cannot recall now, but it was retracted from James' cell phone.
Yes. Now I'm asking you. So you cannot recall to whom it was sent?
No.
And this message was also retracted without him giving consent to access his private messages.
I don't know whether he will give consent or not.
Okay. Was there a warrant for that?
There was no warrant.
So if you do not know to whom he sent it, and you also cannot, from your investigation, establish that this agreement was shared with any other party, the other parties would not know. Is it not so, Mr. Kanyangela?
I mentioned of a lot of emails which was shared. And some of the emails were also shared with those parties.
The 75%.
That's correct.
Can you please direct us to that? Because we haven't come across that where it was shared with other parties.
You don't have all the emails. That's why I say if the emails are not yet disclosed to you, we have to go through and see what I'm saying.
Now I'm putting it to you, Mr. Kayangela, that the first applicant and the other people, besides now what you're testifying, apparently that James knew, no one knew of this arrangement.
They were defending themselves. I don't want to misquote what is in the emails.
It's because they don't
But what
exist.
I know that it was discussed.
I'm putting it to you, it does not exist. And hopefully you can get them during the break.
And I say it exists.
Will you be able to obtain them for us during the break?
It's a lot of documentation that I have to go through.
So you won't be.
Emails is having things more than 10 hash files, or more than 6 hash files. So we have to go one by one.
So you will not be able to provide us, yes or no?
Not during the break.
Tomorrow?
Tomorrow possibly, yes.
Okay, then we can revisit this. Now, this 75%, 25% arrangement, Mr. Esau testified he wasn't even aware of that. Any response?
He could not know.
Pardon?
He answered he could not know.
Okay.
And this 75%, was it paid at the end of the day? The full 75% of the usage quota or the usage fee?
The 75%, it was payment, it was depending on how much the quota will be paid for. And there were money paid, as indicated, there were money paid into Ndavala account in Dubai. And according to the statements of Johannes Stephenson, that was a 75% agreed upon to be paid over.
And in your investigation, could you establish whether this constituted 75%?
I did not investigate every transaction, but I believe that is a 75%.
You believe
That
so?
was paid into Ndavala's account.
Now, Mr. Kayangela, this is a court of law, and I believe Justice Sutele recently indicated we are not here for beliefs, we are here on evidence. In your evidence, could you find that it constituted 75% and not
I
your beliefs?
indicated to you that I did not investigate every transaction to say that yes, this is a 75%.
So you don't know? Yes or no?
I don't know whether you're expecting me to know if I say I did not investigate it.
Then you can just say you don't know, Mr. Kayangela. You can just answer the question.
I will just answer it as I answer it.
So you don't know.
I don't need to be directed what to answer to you.
Your Lordship, if Your Lordship may please direct the witness to answer. I believe that we've been back and forthing on this aspect. It's a question and he can answer. It's not a difficult question.
Would you say it has not been answered? The question has not been answered?
He said he believes, so I'm asking you, so you don't know. And there can only be one or two answers, yes or no, whether he knows or not.
I take it that he does not know, since he's saying that he did not investigate the issue.
As it please the court. Your Lordship, just while I'm engaging Your Lordship now for the witness, if the Lordship can just give a direction to the witness to just answer the question so that we don't go back and forth.
Yes, yes. Mr. Nyangela, you are aware of that. You have been in
Understood,
court
my lord.
many times, yes.
And this 75% that was allegedly paid, the money that was paid into the bank account in Tunduvala, could you establish what happened to this money?
We are still waiting for the feedback from Dubai authorities that you requested through the MLA.
And when did you submit this request?
The first request was submitted during January 2020. The second request was submitted during March 2022.
So we've been waiting now for 3.5 years and no answer to date.
MLAs are being dealt with through the Ministry of Justice. So we are waiting to get feedback from them.
What happened? Whether that money was in fact received into that bank account and what happened to that money.
I have already testified before that the money was received. There is bank statement of the accounts from the money was transferred to. There is a statement of the financial manager of Sameri who said they paid money into that account. There are transaction documents that show the money was transferred into that account.
Mr. Kayangela, do you recall your testimony about 2 days ago, a day ago, whereby you confirmed that you confirmed during cross, in order for you to establish whether the money was received in another bank account, you would have to go to that bank account, get those bank statements and see whether the money was indeed received there. Is it not so?
It is so, but there are other accounts that supporting that, yes, the money was transferred to that account. And the transactions documents are there.
May I just find out the reason why we are revisiting this issue. I thought it was exhausted. Did it come out because of the your cross for today? You really dealt with
Yeah,
this
Your
issue?
Lordship. I'm moving on from the aspect.
Okay.
Yes.
All right.
According to Johannes Stefansson, what was supposed to have been done with the 75% of the usage fee?
This was bribe money for the accused persons. They have to be shared among them.
Amongst them.
Yes.
Okay. Now, from the evidence that you have obtained in your investigation, could you establish whether any of those monies that was paid into the Dubai account made its way to any of the accounts of the co-accused? In particular, the first applicant.
I don't know how many times I have to repeat this to say that we are still waiting to see as to what had happened to the money.
So you don't know.
So far, I don't know if the money is moved.
You also testified, if you go to page 798, in essence, all the way through to (805), 806, yes, all the way through. You testified on emails and documentation relating to letterheads and business cards that were prepared for Nemgomar.
That's correct.
My instructions are that the applicant was unaware of this setup, or if these emails are even legitimate, and he's just unaware of all of this information.
Which pages again?
798 to 805, Your Lordship.
798 to 805.
And he only came to learn of this during the receipt of disclosure.
There's a possibility for him not to saw these documents, or not for him not to be aware of them. But he is aware of the name Nangomar Pesca SA.
We will get to deal with that one.
Yeah.
And that would also include the cooperation agreement that was allegedly signed between Escha Holdings and Nemgomar Peshka. He's not even aware of that. The one that you also testified on.
The possibility is there.
Now you recall you testified on the letter that was, I believe that we've already addressed that aspect, that the joint letter that was from Francisco Santos and Mr. Shangala.
Yes.
Yes. So what Mr. Esau, just to, I know I don't want to repeat, but just to add another aspect, besides referring it to, he then testified that in retrospect, he came to learn that it was for him, if the letter is, it's a correct, accurate letter, a valid letter, that it is an inappropriate letter because two emblems can't appear on the same letter. That is what he said. Two emblems, country emblems.
Yes.
Yeah. And he is saying that he agrees in essence that it's not how it should be done.
Yeah, this was confirmed by Dr. Kawana as well.
Now, he also testified that, and I'm just putting his version to you, that he's disputing that he gave any authority and also that he delegated Mr. Shangala to act on his behalf or any of the other co-accused to act on his behalf or that of the ministry.
I disagree to his statement because he was a person who involved Shangala in.
And what he's also testifying is that it was not him that called it Mr. Shangala, but it was the permanent secretary that utilized Mr. Shangala.
My Lord, we mentioned yesterday about letters. We talk of the letter of the request for the applicant to travel. That letter was signed by him. We talk of the attachment on that letter. The letters under the heading of the Office of the Minister. Those letters could not be prepared by permanent secretary. The permanent secretary, if you look to the letters that she might or he might prepare, they are on the letterhead of the Ministry of Fisheries and Marine Resources. The applicant is having a personal assistant who could draft letters for him. Cannot be the permanent secretary. All letters signed from the Office of the Minister could not be drafted by the permanent secretary. And you find in some letters, you can find the PS is also copied. There is no way a PS can draft a letter and copy it to herself. For what? If he's already having it on the computer. That is clear indication that these letters, Office of the Minister, they were never prepared by the permanent secretary.
Mr. Kayangela, besides drawing conclusions, did you investigate how letters are prepared within the ministry and how it was prepared during that time? Did you investigate?
What I'm saying, the applicant is having a PA, personal assistant in his office. And the issue of drafting letters of his office can only be done by his personal assistant. We are having officers, we are having director generals, they are having their PAs. Their PAs are the ones who are drafting their letters, not the ED.
I'm talking about ministers.
Even ministers, they are having their PAs.
Just listen to my question again, Mr. Kayangela. Did you investigate the internal processes and how the administration works in that ministry?
I did not investigate that.
So if you did not investigate, you would not know besides you drawing conclusions.
I drawing conclusion on what I experienced.
So your conclusions are not based on any investigation conducted by yourself, correct?
As I said, a permanent secretary cannot write a letter and copy it herself in the letter under the head of the Office of the Minister. Those letters, they were drafted from the Office of the Minister. And the permanent secretary is not a PA to the minister.
Mr. Kayangela, did you hear what my question was?
Yes, I hear what your question was.
What was my question?
And this is how I answer it.
What was my question?
You ask whether I investigate the process, the internal process.
And did you? Yes or no?
No.
Now you also testified on exhibit XX8.
What page number is it?
Do you have exhibit XX8? We are now, for the time being, done with XX6.
That's it is which one?
It is the one that starts off with a
1006.
1006.
Okay. Yes, I do have it.
You referred the court to, so I just quickly want to get that. Sorry, Lordship, I might just have my numbering incorrect here. Court may just bear with me for a second.
That's fine.
I know, Mr. Kayangela, I wanted to take you to the meeting memos, but we've already dealt with that.
Okay.
Yes. Now, Mr. Kayangela, when you testified, you also mentioned that a certain document was retrieved from Mr. Esau's farm. Do you recall? Concerning some herji that was taken to the farm to him.
I have indicated
profile.
a document that was found at his house.
What is this document?
I don't know the name of the document, but it was with regarding to frozen fish. I will only be able to give the correct name of the document if I come across the document.
Frozen fish, did it relate to this matter?
Just correct.
Because you mentioned it during cross-examination that yes, he was aware of some herji group of companies they've engaged and there was a document that was sent there. So we want to explore what the document is.
If you give me time, I will bring it after. When you start with the afternoon session. And I know it is attached to the statement of Mr. Oliphant who conducted the search.
Okay. Then we can deal with that one. But what you're saying is that document relates to the discussion of, it relates to the setting up of the scheme.
I cannot confirm it now. Let us deal it with after that, if I do have it.
Now if we go to Exhibit XX8, sorry, my numbering is a bit, I believe it's XX6, sorry. Sorry, Your Lordship, it's actually XX7. My apologies to all parties.
Okay.
XX7.
Yes.
It's volume 8.
He is saying my approach to my co-accused. We are not his
My-
co-accused.
My learned friends.
I did not hear that part.
I know my learned friend would not want to be called a co-accused. My apology. Let me retract to my co-accused. Now, at page 800, and you also testified on this bundle, you recall that?
Yes, I recall.
And you took us through some of these meetings, or at least some of these documents.
Yes,
And the first one that you started off was with 861, or not the first one of them,
861.
861. Mhm.
Yes, I'm on that page.
You testified that these were meeting memos
That's correct.
in respect of an Angola visit 15 to 22 January 2014.
That's correct.
And these particular meeting memos were provided by Mr. Johanna Stephenson.
That's correct.
Who prepared them?
I don't know who prepared it.
So Mr. Stephenson could have just typed them up and provided you with it as part of his statement.
He will be able to explain as who prepared it, since it is attached to his statement.
I want you to go to page 870 on that bundle.
I'm on that page.
Can you please take us through the document?
Okay, the document is an email from Saki Shangala dated 23rd December 2013 to Johannes Stephenson and Sigurd Olason with the subject Small Profile of Sameri. Dear Vikings, I trust you are well. I really need your assistance on an urgent basis here. The minister needs to go brief the president on the Nangomal matter. The question might arise, who is Sameri? They will have a brochure that the minister can print out, a 2-page or so. Please send to me ASAP. Saki.
ASAP. Now, we obviously not accepting the validity of this particular document. We are challenging the authenticity, but it has been provided, and it's
Yes.
part of the bundle.
Okay.
And from a reading of this email, one can establish that the minister, do you know perhaps which minister is referring to?
Should be the Minister of Fisheries and Marine Resources.
Oh, no.
Since all this, Saki and Johannes Stephenson, Saki was a representative of Nangomal, Namibia, on the Namibian side. Bernhardt Stephenson was a representative of Sameri that was operating in Namibia. So the person to be briefed is the former Minister of Fisheries and Marine Resources.
Mr. Esau.
That's correct.
And the president of Mr. Esau is who? During that time was who?
I cannot
2013
I cannot recall.
was Dr. Ifikipunye Pohamba.
Can be possible.
So according to this email, allegedly, Mr. Esau had to brief the president on the Namgomar project. You see that?
Nangomal Meta.
The Namgomar matter.
Yes.
Okay, and what is the Namgomar matter?
It's a scheme that he had established.
The scheme. So Mr. Esau was supposed to discuss this with the president of Namibia.
That's correct.
And did you obtain a statement from the president? Did you investigate this?
I did not.
So are you, if one reads this thing, it would appear that the president was briefed and he knew all along.
Unless the applicant can say that he briefed him or he did not brief him. I don't know whether he was briefed or he was not briefed.
Now the applicant did not brief the president.
Then I cannot say he was briefed.
Yes. In fact, what the applicant, it's a further example here, if this is to be accepted, the applicant's name was being used. And even here, the president's name is being used. Is it not so?
There's no name of a president mentioned.
Okay, the president. It's a position, the person.
Might be
Still
the
a person.
position.
You can answer, Mr.
It was
Kayanda.
mentioned, yes.
Yes. So names were being used here, you would agree? Or titles of persons.
They were used, but for him, I cannot say he was not aware of what was happening.
No, I mean, if you look at the email, it says the minister, Minister Esau, we've now gone through the steps. Minister Esau had to go see the president. At that point in time, it is common cause that the president was Dr. Ifikipunye Pohamba. that he had to go see the president and brief him on the Nemgomar matter and even take a brochure, such an urgent meeting, a brochure to the president. Is it not so?
It is so.
Yes.
But
And you,
what I'm saying is that I cannot exclude the applicant to say that his name was used. He was aware of what was happening.
but you would exclude the president.
I can exclude him because I don't know. I never saw him benefiting from this. But the applicant did benefit from it, from this scheme.
And you never obtained a statement from the president.
No.
In fact, Mr. Kayangela, you didn't even investigate what is being said in any of this documentation. You just drew conclusions.
If I could investigate every email, I don't know where we could be today.
You have a team,
Yes, I do have a team.
and the purpose of going through this documentation is to extrapolate information and to investigate this case. Is it not so?
It's so bad
Yes.
what I have investigated is enough.
So you decide where the line should be drawn.
What I have to prove the case is enough.
So you were selective in your investigation. We can move along if you don't want to answer. Now, what the minister came to testify, and was also part of my instructions, is that according to him, he believed that everything was above board in respect of the workings on the bilateral agreement, that there was a joint technical teams that was in essence spearheaded by the permanent secretary, and they continued working on this agreement to iron out all issues after it was scrutinized by the then Attorney General. If any-
Minister, are you referring now?
Mr. Esau, my apologies.
Oh,
You can respond.
possible I did not follow your question. Just repeat your question again. Or your comment.
Yes, my instructions are that, and I please want you to listen.
Yeah, if you are talking so low, sometimes I cannot catch up.
So you want me to raise my voice?
You can rest, but don't shout.
Okay. If you do not hear me, Mr. Kayangela, you must just say that you do not hear me, correct?
Okay.
Now, Mr. Esau testified that he was under the impression and the belief that everything was above board, that the bilateral agreement was discussed between the joint technical teams, and that the Namibian technical team was spearheaded by the permanent secretary with the management, and that they were working on this agreement after it was received, the scrutinized copy was received back from the Attorney General.
I don't have that evidence.
You also came to testify that, in fact, after the agreement was scrutinized in December 2013 by the then AG, there was, besides the further working on the document, there was a further interministerial meeting on the status of the agreement on the agreements between Namibia and Angola that was held on the 24th of February 2014. Are you aware thereof?
I'm not aware of that.
This interministerial meeting was attended by Ms. Aina Ipinge, the Deputy Director for Policy Planning and Economics.
The meeting in Namibia,
Interministerial
interministerial,
interministerial meeting relating to the agreements between Namibia and Angola.
held in
24 February 2014. It was held at the SWAPO head offices.
On that I'm not aware of.
You're not aware. And what he also then testified was that pursuant thereto, there was a further fourth session of Angola and Namibia for the Joint Commission of Cooperation that was held in Luanda from the 10th to the 12th of March 2014.
I recall of seeing the minutes of that meeting. I confirm there was such.
And that there was then a report to Cabinet from the Ministry of Foreign Affairs during March 2014.
I'm not aware of the report.
So, having regard to that, he then testified that, look, as I was briefed, everything was above board. I didn't see anything untoward. And I believed and I trusted the people and I acted on the advice of my permanent secretary, who was my principal advisor.
I don't know why he said everything was involved, was on board, and he decided to include people who were not employed by the ministry. At first place, I don't know why he involved Mr. Shanghala in, if there was a technical committee.
Mr. Kayengela, I will not back and forth on you on that one. I've put his version that the delegation was decided upon by the PS.
I'm not aware of such delegation.
Sorry, I was just received the instruction that the meeting was actually held at Parliament and not at the SWAPO head office.
Oh, no, I'm not aware of that meeting.
Now, Mr. Kayengela, you also testified that the Attorney General was not aware, and you can correct me if I'm wrong, that Mr. Esau would attend to the signing of the MOU.
He was not aware.
Aware
I
that the
cannot,
minister or the ministry will attend to the signing of the MOU.
I cannot recall of testifying like that.
Was he aware?
The Attorney General.
The Attorney General, Mr. Albert Kawana.
What he said is that if there was an agreement to be signed between the two countries, there should be a person from the office of the Attorney General. And for him, he saying there was no one from his office who went to attend that signing. And what he mentioned further is that Saki Shanghala was not supposed to represent the government on that memorandum of understanding that was signed.
As a delegate. Was he aware that Mr. Shanghala would attend?
I don't know whether he was aware.
And let's say, for example, if he found out that, yes, there's a signing of the MOU, he then could have advised, as the principal legal advisor, the minister, to say that, no, this is what should happen.
He's a witness in this matter. I think if there's anything that needs to be clarified as to what he was supposed to do, that
He
is
can
him who have to clarify it.
But you testified that he also indicated that it's standard practice that someone from his office should attend.
That is what his statement is saying.
And did you find any cabinet handbook to that effect, that that is a standard practice?
I did not.
Do you know whether Mr. Esau was aware of the standard practice or advised of the standard practice?
I don't know.
Because according to my instructions, there's no such standard practice, and he's never been briefed on such standard practice. And he would like to know, where is this recorded, the standard practice? You would not be able to assist the court.
It's only Dr. Kawana who can assist in that.
Lordship, I see it's 11:30. Can we have a brief comfort break?
No, no. proceed at 12 o'clock. Court adjourns. proceed.
As it please the court. Mr. Kayangela, did you have an opportunity to investigate how approval is normally granted for the ministers to travel out of the country?
I did not investigate that.
My instructions are that if the minister wants to travel, he must first seek permission from the president.
I saw the letter of request that it was addressed to the president, yes.
And the president would then be advised by the Minister of Presidential Affairs.
Yes,
And the Minister of Presidential Affairs would then be the one that would respond to the respective minister and inform the minister that yes, you've been granted permission to travel.
that could be the process.
So, for example, in the request for 2013, that request to the president would then be referred to the Minister of Presidential Affairs.
Yes,
And then the Minister of Presidential Affairs would then see, okay, this is the minister traveling, and if there is delegates provided for, then he would also be able to see who the delegates are, and then he would be able to advise who should travel.
yes,
Okay. So in this regard, now let's take exhibit XX5, the one that we are disputing that the attached list of delegates did not form part of the letter, that one. XX5 Roman 1. Are you there?
yes,
Yes. So once this letter then is addressed to the president will then have to engage the office of the Minister of Presidential Affairs.
Just be clear, Mr. Biekas, it's not very, the way you are capturing it, it's slightly confusing. Sometimes you are saying the letter will be sent to the Minister of Presidential Affairs, who will then looks at
Okay. Let me
the,
rephrase
yes,
as I'm indebted to the court. Once there is a request for permission to travel, the letter will be addressed to the President of the Republic of Namibia. That letter will then be channeled through the office of the Minister of Presidential Affairs. And the office of the Minister of Presidential Affairs will then engage and then will then give feedback or provide a written response to the minister concerned that yes, you may now travel.
I'll follow.
So if this letter, for example, was sent to the president then have to channel it through. It's channeled through the office of the Minister of Presidential Affairs. The Minister of Presidential Affairs will have a look, and then he will say, okay, you've been granted permission, this team can travel.
Yes, I'll follow.
And in this particular instance, even this one had to go through the office of the Minister of Presidential Affairs. Do you know whether permission was granted for the minister to travel in 2013?
I'm not aware whether he was granted permission.
You did not investigate it. You just draw conclusions from the documents.
I saw one letter where permission was granted, but I could not recall now whether it is for the 2013 or is it for the 2014.
2014.
trip.
Okay. And even for the 2014 one, where the minister had to go and sign in June 2014, I believe it's June 2014, where Mr. Esau, the former minister, had to go sign the MOU. There should have also been a request for permission to travel, correct?
That's correct.
And that should have also been channeled through the office of the, what do you call it, the office of the Minister of Presidential Affairs.
That's correct. I think that is the letter I was also referring to
You referred to it.
for the 2014, yes, the
Okay.
permission.
So go to exhibit XX7. Are you there?
Is it this one?
XX7 is the one written volume 8 on top.
I hope it's this one.
No, no. Yes, the appeals exhibits, Mando.
It's the same document I'm showing you.
Okay. Page 873.
Yes, I'm on that page.
12 June 2014. This is a letter from the Office of the Minister of Presidential Affairs.
That's correct.
Invitation for a working visit to the Republic of Angola for the signing of the Memorandum of Understanding on Agriculture and Fisheries sectors 17 to 18 June. Paragraph 2, the letter is addressed to Honorable Bernhardt Esau MP, the Minister of Fisheries and Marine Resources. I have been mandated, and I read from paragraph 2, I have been mandated by His Excellency, Comrade President, to inform you that permission has been granted to travel to the above-mentioned country. Given the fact that the National Assembly is in session, this authority is subject to obtaining leave of absence from the government chief whip. You there?
I'm there.
Now, the Minister of, during 2013, during 14, do you know who the Minister of Presidential Affairs was?
It was Dr. Albert Caron.
And during that time, Dr. Albert Karwana had a dual role. He was the Minister of Presidential Affairs and he was the Attorney General at the same time.
That's correct.
So for any request that it would have come through, he would have been able to know not only that there is a travel, what will happen, an agreement must be signed. If it's coming permission through the office of the Minister of Presidential Affairs.
Yes.
And he was having both roles, so he would know as the Attorney General also who would form part of the delegation.
If he's informed, yes.
If he's informed.
Yes.
Because you refer to a letter to say that, yes, the delegation is attached.
Yes. There's a list attached.
So if the Attorney General, who's also the Minister of Presidential Affairs, sees that, okay, no, it is standard practice that someone from the office of the Attorney General must attend to the signing of a bilateral agreement or agreement between two countries, someone from my ministry or from my office should also be there. He can then advise.
I don't know whether the names of the delegates was also provided to him during that time.
During that time. Mhm. But even for the first one, if you are saying that the names of the delegates were given to him, he would be aware.
If it was given to him, yes.
Because all correspondence goes through his office.
For the permission to travel, yes.
Yes. So, from the correspondence, this correspondence of 12 June 2014, the Attorney General was then aware that there would be a signing.
That's correct.
And then he could have advised that if there was a standard practice, that one of the people in his office of the Attorney General must also be present for advice.
No objection, my lord.
Yeah.
The witness, the witness evidence is that where there is a signing of an agreement, the Attorney General's office will be involved, not where there is a signing of a memorandum of understanding. The Attorney General had already advised that this is not an agreement, it's a memorandum of understanding. The witness did not testify that the Attorney General will make sure that where there is a signing of memorandum of understanding, there will be someone attending.
Okay. Thank you, Mr. Varantesa.
No, Your Lordship. From my understanding from the witness testimony is that the Attorney General indicated that, for example, for this one, someone from his office should have attended to the signing. That is how I understood it. But the witness can confirm.
Yes.
Yes, that is what he says. Somebody should be involved from his office. Yes,
And that was in respect of the signing of this agreement.
that's correct.
Yes. I'm not sure if my learned friend has an objection further. So that was in respect of this particular MOU that was signed. He gave a statement in
The
respect of that.
statement he gave is regarding
Yes,
the
my lord, it's
memorandum
not,
of
a,
understanding
it's not
that
an
was signed,
objection as
yes.
such.
I don't know if you
My
are done.
learned friend is interchanging. At one stage he says memorandum of understanding, at one stage he says agreement. Can he stick to what he believes this document to be? Instead of interchanging those two words. Because he is aware that the state is saying it's not an agreement, it's memorandum of understanding. He is using the word interchangeably, agreement, memorandum of understanding, and that will confuse the witness.
But also the witness should be aware as to what was to be signed at this stage.
Yes.
I think that it's the state's case that it was just a memorandum of understanding and there's no agreement.
That's correct, my lord.
But he is confirming to say
That, I think it's because the way questions are being posed, there's interchange of words, memorandum of understanding and agreement.
well, of course, from how you are capturing it, his evidence might be contradictory.
Yes, my lord.
Mr. Biekas, are you using both words at the same time? Remember, this issue is contested.
Your Lordship,
Each party should just stick to their respective version.
my understanding
Yes.
is a memorandum of understanding is an agreement. It's signed between two parties. It constitutes an agreement. You get different titles of agreement. You get a lease agreement, you get sale agreement, you get a memorandum of memorandum of agreement. It's still an agreement, but I will refer to it as an agreement then. The MOU is the agreement that I'm referring to.
Okay.
Yes.
Yes. That's what. Mr. Ganyangela, would you like to comment on these exchanges?
I will just comment by saying that these questions were follow up on this letter that I was just reading, or which he read. And from the letter itself, if you look on the subject, it is referring to the memorandum of understanding. And that is what was signed.
Yes. And in respect of the signing of that memorandum of understanding, as referred to in this letter, was it the Attorney General's view that someone from his office should have attended to the signing of that MOU as per standard practice?
His statement was based on this memorandum of understanding that was signed.
So he was saying someone should have traveled with to give advice.
That's correct.
Yes. So that then clarifies the aspect. Now, given that he was then aware that there would be a signing, and if there was a need for someone for his office to be a standard practice, he could have advised accordingly to ensure that someone attends.
It depends if he was given the list of those who are going to attend.
So he won't be able to assist.
I will not assist on that one.
Now, after the agreement was then signed, I want us to briefly deal with the procedure. After this agreement was signed, what is the, or let me rather say, after fisheries agreement is signed, I will refer to fisheries agreement is signed in terms of section 35, did you investigate what procedures should be followed?
I did not investigate that.
Did you investigate how a fisheries agreement is normally implemented?
I did not.
Did you investigate what content is normally contained in a fisheries agreement?
I just read the one of the memorandum of understanding that was signed. I did not read any others.
You did not read any others.
Yes.
So you did not read the one, for example, of Mozambique, the fisheries agreement.
No, I did not read it.
And these agreements, would they normally include how the quotas should be allocated?
As I said, the one I read, it did not include such, and I did not read the others.
So you didn't compare this agreement to any other agreement?
No.
Okay. So you would then also not be able to say what is the process that is followed in terms of the nomination of a company to which the quota should be awarded?
Can you repeat the question again?
You would then also not be able to shed light on the process to be followed in terms of how a company should be nominated in terms of a fisheries agreement?
No, I did not.
I want us to go to divider 18 of bundle 1. Do you still have bundle 1 with you?
I gave it back. I don't have.
You can pass to the witness.
Okay. Divider?
18, exhibit S1. Are you there?
Yes.
Before we start off with the document, so what you just testified now or confirmed during cross-examination is that you do not know and you did not investigate how the entity would be nominated.
That's correct.
Okay. You also did not investigate how quotas are awarded in terms of Section 35 of the Marine Resources Act.
Our quotas are awarded. I did testify about referring to the statement of Mr. Moses Mauri Ngirila.
Yes, sir. That is in respect of the right holders that would normally apply. You recall that? There would be a government gazette that would go out, then the local companies would apply.
Yes.
Yes. Now there's a difference in terms of Section 35 quotas that are allocated. Did you investigate how the Section 35 quotas are allocated in terms of fisheries agreements?
In terms of Section 35,
Yes.
if it is allocated to SADC countries,
Yes. It need not be just SADC countries, it can be international companies also.
what I have read is SADC countries.
Okay. And how is this process then? What is the process?
The application is still to be done with the Office of the Permanent Secretary.
So
But the
there's,
allocation is to be done by the Minister.
and who applies?
Who applies?
Yes, who applies? In terms of Section 35.
It's an agreement that is entered into. Who applies? I don't know whether somebody have to apply, but as soon as there is an agreement, the minister can now allocate quotas.
So but you said that there is still an application that is made to the permanent secretary, and then the allocation is made to the minister. The
Yes.
allocation is made by the minister.
Yes, I read one of the regulations that is saying that if the person is applying for the right, or if a person is applying for the quota, it has to be done to the permanent secretary.
Mr. Kayengela, did you investigate how these Section 35 quotas are allocated? If you did not, you can just say.
I did not, but as I said, there is a letter that is indicating as to how the quota is being applied.
The regulations.
And in terms of the act, it's only the minister who can allocate the quotas.
And how is that process?
The process of
The application. Who applies? How do they apply? You are the lead investigating officer on this matter.
who applied in terms of the quotas, it's all Namibians, except it's all Namibians who can apply to have fishing rights to cash quotas.
So once there, in terms of Section 35, and you can correct me if I'm wrong, anyone can apply, any Namibian.
That is only related to agreements
Yes, now,
between the countries.
agreement between two countries, then what is the process? That is what I'm asking. If you don't know, you
No, I
don't
don't
know.
know that process.
Okay. Now, if you go to Exhibit S1, at page 28. The next page, page
Yes,
2,
yes.
it's 28 on top, no?
Yeah.
What is indicated here in this letter? Now, firstly, Mr. Esau testified that this letter was also prepared by the permanent secretary.
Which I am not agreed with.
You were not there when this letter was prepared.
I have already said, the,
Yes.
the letters from the office of the minister will not be prepared by the PS. The minister is having a personal assistant. And this is the person who could draft his letters.
But you did not investigate how the administration works. You confirmed that.
I did not investigate that.
Yes. And a PA, is a PA highly qualified person that has knowledge of legislation and how international agreements would work and how the ministry would operate? Would they know what to put in letters?
I don't know what is their job description as to what is expected from them.
They are just normal secretaries, and my instructions are that they don't draft on behalf of the minister, that the PS and the people that are qualified, they would prepare, because it's important documents that are being prepared and not done by PAs.
I disagree.
But you would not know since you didn't investigate. You were just disagreeing for the sake of disagreeing.
Yes.
What Mr. Esau also came to testify is, if you go to that second paragraph, that in terms of the MOU on cooperation in fisheries of aquaculture, he indicated that we nominate the Angolan fishing entity, Nemgomar Pesca SA, and or its nominees in conjunction with the Namibian fishing entity, Nemgomar Pesca Namibia Pty Ltd, to harvest marine resources in the maritime jurisdiction of the Republic of Namibia. Now, he came to testify that, yes, this name is the entity that was nominated here was nominated on the advice and recommendation of the permanent secretary, as would normally be.
Okay, but as I said, I have already testified that this Nangomal Pesca SA is a non-existing company. So it could not be nominated.
And if you turn the page, there's a letter from the 27th of June 2014 that is prepared by the permanent secretary.
That's correct.
And it's to the director of Pawprint Investments, Stroke Nemgomar Pesca. It's in Luanda, Angola, and nomination for a horse mackerel quota allocation. I have pleasure to inform you that the minister has nominated your joint venture Pawprint to apply for horse mackerel quota in accordance with the Marine Resources Act, Article 35 of paragraph 2. The validity of the nomination will be guided by the MOU incorporation in the fishery sector between the Republic of Namibia and the Republic of Angola. Now, according to this letter prepared by the permanent secretary was aware as to the company that is being nominated and the allocation being done to, or before the allocation comes, who's nominated as the company.
Now, if I look to this letter, this Pawprint investment was never registered in Angola to have such an address in Rwanda. It's a chef company that was purchased in Namibia, and then the name was changed to Nangomal Pesca. And this, although this Pawprint investment was nominated, it was not the company that was being allocated quotas. Those quotas are bearing the name of Nangomal Pesca SA, which is not existing.
Sorry, the quotas were awarded?
Allocated to Nangomal Pesca SA.
And this was communicated by the permanent secretary
Which one?
when the quotas would be awarded. You can go to divider 21.
Yes, I'm on that divider.
Now, the permanent secretary is the administrative head. Applications are normally made to the permanent secretary. In your investigation, could you establish who was responsible for doing due diligence on these companies to determine that the papers are in order?
I did not investigate, but I don't know whether that other letter is also part of these bundles. There was a letter that the minister wrote to the other minister, to the minister of Angola, with regarding to the nomination, in which he indicated that he nominated Nangoma. So only that I cannot see the letter here, if it is also part.
So you did not investigate who's supposed to do due diligence?
No.
And even if an application is received for quota allocation, there would be an evaluation committee.
That's correct.
You did not investigate whether it was the responsibility of the evaluation committee to do due diligence,
No, I don't investigate that.
or whether it was the responsibility of the office of the permanent secretary to do due diligence.
I don't know who was responsible for that.
Because my instructions are that most certainly a minister would not do due diligence. That is for the technocrats. That's why they evaluate,
That can be correct.
and then they recommend after they are satisfied that all requirements have been met. Is it not so?
It is so.
Yes. Just bear with me for a second. Now my instructions are that once the entity has now been nominated and due diligence has been done, and in this instance, Nemgomar Peshka SA, or was it Nemgomar? Peshka SA, in conjunction with Namibian fishing entity Nemgomar Peshka Namibia Pty Ltd. That company can then apply for quotas to be allocated in terms of section 35. Do you have any comment on that?
If it is the process, yes, it can be.
And once this application is then received, it is a delegated function. Previously, all applications had to be made to the minister. The applications will now be made to the permanent secretary. In terms of Regulation 2 of the regulations made under the Marine Resources Act.
Yes, but what I know is that the time this company was allocated with the quotas for the first time, it never applied.
It never applied.
No. That's why they were advised to apply.
Yes, they would normally advise.
But
All companies, let me just explain to you the procedure. All companies, not only for under the agreement with Angola, even under the agreement for Mozambique, they would also be informed that this company has now been nominated and you can now apply.
you are right.
Yes.
But as I said, when the quotas were allocated for the first time, this Nangomar did not apply.
They did apply. They
did
were
not
informed
apply.
to apply.
They did not apply, although they were informed.
You went to go investigate that.
The only application they submit, I think it was year 2015 or 2016. For the 2014, there was no any application.
So if there was no application, then the evaluation committee and the permanent secretary should have known that there was no application, and therefore they can't recommend any allocation to be made.
I don't know whether it was they did the recommendation after the recommendation of or the nomination of the applicant.
The applicant nominated on the advice of the permanent secretary. The company is then informed you can now apply. You've been nominated, you can now apply. An application is then submitted. After the application for quota allocation is submitted with the office of the permanent secretary, there's an evaluation committee that would then consider it. Once the evaluation committee have considered it, it goes back to the permanent secretary. The permanent secretary will then prepare an internal memorandum setting out how the allocation should be done after considering the application, and then it will be submitted with the minister. Do you dispute that process?
I'm not disputing the process.
Yes.
What I dispute is that I never saw any application from Nangomar for the first quota allocated.
So the fact that you did not see it does not mean it does not exist.
You can provide to me if it is exists.
Unfortunately, we don't have access to the offices. We only have to rely on the docket.
I received a lot of documentation from the office of the minister, but there's no such letter, such application.
Let us go to divider 19.
Yes, I'm on that one.
Now, this is an internal memorandum that was prepared by Mrs. Ivelwa, the permanent secretary. You see that?
Yeah, I see.
And that one was addressed to the Minister, Bernhardt Esau.
Yes.
It was copied to the Chief Samuel Nkama, Deputy Minister.
That's correct.
And it's dated here 1 July 2014.
That's correct.
And this is after the letters went out to Nemgomar nominating them and informing them that they can apply, correct?
I don't see anything that shows that it was after or it was before.
Go to
This
page,
letter was written before the.
go to page divider 18. Are you divider 18? Go back.
Divider 18.
You go to the last page.
Yes.
Are you at the last page? It's a letter from the permanent secretary, Ivelua. The last page.
The last page.
Yes, it must be
The
marked
last
exhibit,
page of which divider?
exhibit S2. You don't have an exhibit S2 there.
And that is divider which one?
It must be under divider 18.
There's only one. Okay, S2, yes.
You have it there? Okay.
Yes.
And that letter is dated 27 June.
That's correct.
And it also informs Nemgomar Peshka to apply for horse mackerel quota in accordance with the Marine Resources Act. You see that?
Yes.
So this is what the permanent secretary is informing them.
That's correct.
Yes. And the date there is 27 June 2014.
That's correct.
Yes. And then if you turn the page to the divider 19,
That's correct. The 1st of July.
it's 1 July. It's after.
Yes.
Okay.
It's after.
And now this internal memorandum, it's my instructions, it was prepared after an evaluation was done by the Office of the Permanent Secretary, including the committee. It came then back to the Office of the Permanent Secretary. The Permanent Secretary then prepared this memorandum as to how quota should be allocated, recommended for approval, and also attached a sheet for the additional horse mackerel quota for the 2014 season to be signed off by the minister. You have anything to comment on that?
Yeah, what I can comment is that yes, recommendation used to be made to the office of the minister, but according to Mr. Moses, the minister is the one who have to select as to who should be given the quotas or who should be given the rights.
And did Mr. Moses put this in his affidavit? Because I looked at his affidavit, the statement that he provided to the state, and he doesn't indicate that.
Which?
In terms of section 35.
No, he did not make specific in terms of section 35.
Yes. So, in terms of this process that was then followed, if you go to page 2, there was then allocation of 42,000 metric tons to non-right holders to be allocated as follows. This is what they've recommended. 10,000 metric tons to Fishrot. In terms of the Namibia-Mozambique agreement, they said 8,000 metric tons to Oasis, 1,500 metric tons to Marazul, 1,500 metric tons to Bayamar. Then there's some others also listed, and then the fourth bullet, you would see there, 7,000 metric tons to Namibia. Angola bilateral agreement.
Yes.
Yes. So here the permanent secretary, who is the principal legal advisor and who advised and briefed the former minister, Mr. Esau, is also indicating that this is a bilateral agreement.
Which letter is that? Under?
Divider 19.
Okay.
That is what they were made to understand, that there was a bilateral agreement, but there was not any bilateral agreement.
Who was made to understand that?
Those who prepared this letter.
Was the permanent secretary made to understand that? The chief advisor of the minister.
I don't know why they could not get that letter that the minister wrote to the other minister of fisheries in Angola.
But you recall, Mr. Kayangela,
Maybe what is the relevance of that letter to this question? The letter that we are talking about.
I just want to know the context as how the nomination was done. Because I believe the nomination or the recommendation that had been put in this Exhibit T, it could be made as a result of that nomination.
Okay.
So if the nomination letter is talking of a bilateral agreement, then the possibility is also that the recommendation could be made in terms of the agreement if it is referred like that in the nomination letter.
Well, I'm sure you are aware of the document he's referring to. I think it might have been presented. Mr. Marondes?
Yes,
The
yes,
letter
yes.
that, because he's saying it's quite important for him. He wanted to have a look at it. And he's of the view that it's as a result that these allocations were made in this way. So if he can have a look at it, then it will assist him.
There's a letter which is part of this
Or probably maybe
bundle or one. I don't know if I can just refer, if that's what it means, my lord.
Yeah.
If you go to divide 21, there's a letter dated 7 July. Is that the letter you're referring to?
Mr. Kanyangele?
Your Lordship, I see it's almost 1 o'clock now. Perhaps we can take the break and then we can sort it out because I want to canvass this aspect.
That's fine. But
Okay.
Mr. Marondes just assisted you. Is there no letter under divider 21? If it's not the correct letter, you can just indicate that it's not the letter. Divider 21. Is it not the letter you are referring to?
It seems it's not the letter, my lord.
Okay.
I will just see whether I will get.
No, that's fine. Then we'll break for lunch and resume at 2:20. Court adjourns.